Sanika, this is Jenny, Ryan, John, Julie, and Jerred. Say hi, everyone.
How's it going?
So yeah, we're going to talk to you about our case today. It's about euthanasia versus death with dignity. We're looking at two specific cases. We have Kevorkian and Maynard. Just going to start out with a brief description on what the difference is between euthanasia and death with dignity.
Yeah, so euthanasia is basically when the physician administers the lethal dose, effectively killing the patient. And death with dignity is when the patient administers it to themselves, however the prescription is written by a physician.
Awesome, yeah, so death with dignity actually gained a lot of steam in 1993, and then in 1994, Oregon became the first state to pass the death with dignity law. This allows people to end their lives through voluntary self-administration of lethal medications. The most commonly associated name with this is actually Dr. Kevorkian. So his situation was that in 1999, they found him guilty of second-degree murder because he administered a lethal dose to a patient with Lou Gehrig's disease. So the issue was that he made a videotape of himself injecting the lethal dose to the patient, Mr. Uke, and he played it on 60 Minutes. So he was tried at his trial, and they found him guilty of this. However, he had been tried many times before because he went around the country doing this thing where he would say he could help people have an easy passing with their terminal illness. However, it wasn't legal at the time, and he wasn't the one administering it. He would give them the lethal dose. But now that he had a videotape showing that he was the one that administered it, he was tried and put into jail for about 9 years, and then he was released when he promised not to conduct another assisted suicide. And then now we have Maynard.
Yeah, so Maynard is the death with dignity case that we looked at, and basically Maynard was a patient, Brittany, who moved to Oregon after being diagnosed with a terminal illness. She had brain cancer, and after she first got her diagnosis, she went through with surgery, and they removed the tumor, and it came back really quickly. So she was given about 6 months to live, I believe. So after this diagnosis, she moved to Oregon, where death with dignity, I cannot say that, was legalized, and went through with it. Basically, she was able to administer her lethal dose to herself. She set her death date, I believe was November 1st, and so she administered it within her 6 months that she had left to live, which is I'm losing words today. It's a requirement of death with dignity to be within 6 months of, have that prognosis of 6 more months to live. One thing with death with dignity is that you do have to request it 3 times to a physician. So you request the intent to, or the assisted suicide. You request it 3 times, twice orally and once with a written request to be fulfilled. And then I believe you also have to go through psych evals and make sure that this patient is competent and knows the consequences of death with dignity.
Yeah, and I think the big thing with Maynard was that she lived in California, so she had to go through a lot of the huge process to be able to just do something as what someone would think is a basic right. So that's the big issue here is she had to move to Oregon, she had to gain residency, she had to live there, and that really Dr. Kevorkian went to jail the whole euthanasia aspect kind of died down in the public's eye, and then when Maynard Maynard's case happened and she brought it up on social media, it kind of blew up, and people started thinking like, oh, like I want my state to have this opportunity for me, and that's when like a lot more states started looking into death with dignity, and I think
so there's currently 10 states who allow this: California, Colorado, the District of Columbia, Hawaii, Maine, New Jersey, New Mexico, Oregon, Vermont, and Washington.
Yeah, and then the ethical.
So moving on to the ethical issues and the bioethical principles, we found that euthanasia and death with dignity have very similar ethical issues, but they are at varying levels. Like Brian mentioned, so death with dignity is also known as physician-assisted suicide. It's legal in a couple states, whereas euthanasia is not legal in any states. So some of the pros that people have for euthanasia and death with dignity include allowing patients to have the autonomy to make end-of-life decisions. That's really what death with dignity means, that they get to control how they end their lives. And then it also argues for the beneficence of these cases, because a lot of people say that it's unethical to have people living really like financially stressful or really just medically impossible situations. And so instead of having them suffer through those lives at the risk, or sorry, at the expense of just staying alive, they want to be able to show some compassion and, you know, end it. So other pros for that are people can leave hospitals normally against medical advice if they want to. So a lot of people say that the benefit of having death with dignity is that they should be able to have the right to hasten their death. And another benefit of legalizing death with dignity in all states would be that if you legalize the practice, you can open the discussion for standards and procedures so that there's uniformity across states. And with euthanasia, it's worth noting that there is a decrease in autonomy for the patients because it's not the patients who are actually administering the lethal dose themselves. I also thought it was really interesting because Kevorkian was a strong proponent of death with dignity and wanted to bring these rights and these bioethical issues to light, which is why he why he recorded it and gave it to 60 minutes, right?
Yeah.
60 minutes. And it's actually also interesting to note that while he was the one who gave the lethal dose, the patient, Thomas Uke, his family, were his best defenders in his court case. So they really didn't think that he deserved to be jailed. However, like Sanika mentioned, he was found guilty of second-degree murder and sentenced to jail. He was actually released early at his first, what do you call it?
Appeal hearing. Parole.
Yes, parole hearing at 8 years. So, yes. And now Jerred will talk about the cons of these.
Yeah, so a couple of the ethical cons or arguments that have been made against both death with dignity and euthanasia is there's like a large potential for abuse, and so that would get into the ethical concept of non-maleficence. And I think there's also an argument for justice here, so that these types of strategies might be used for cost containment for hospitals or for individuals. So certain patients, especially ones that are without financial means, might be pushed towards an assisted suicide to alleviate familial, financial, or emotional burdens. And so, yeah, there's a lot of worry towards non-maleficence being abused. And then also potentially the concept of like paternalism of the doctor deciding care and not really letting the patient control the care. So like Julie was saying, the abuse of autonomy, that there's just a large potential that the physician might just, make choices or unintentionally make mistakes in diagnosing the illness. And then this is the type of situation where if you make the mistake, you can't go back. right? So that's, I think, why currently euthanasia is not allowed in any state, is that they're just making that argument, this is a mistake you cannot make. But yeah, so that leads us towards discussing what are the implications like currently for healthcare. Jenny?
Yep. Yeah, so in 1984, after Brittany Maynard moved to Oregon, the Death with Dignity Act was brought forth as an end-of-life option. It's governed by state legislation that allows certain people with terminal illness to voluntarily and legally request and receive prescription medication from their provider that will hasten their death and give them peaceful, humane, and a dignified manner during their death. Some qualifications to meet this criteria in order to even be considered is that you have to be an adult resident of a state where such a law is in effect. I think those were listed earlier, but just to restate, California, Colorado, Oregon, Vermont, Washington, D.C., Hawaii, Maine, and New Jersey. So you have to go and establish residency. You also need to be capable of making and communicating your own healthcare decisions. So you won't be able to be in a coma, something that would be not allowing you to be capable and competent in making those. You have to be diagnosed with a terminal illness that will lead to death within 6 months, as confirmed by qualified healthcare providers. And you also will need to be capable of self-administering or ingesting the medications without assistance. So John will take us through another, I was gonna add on to that, sorry. The offside of this, the other hand, would be that the AMA worries that legalizing physician-assisted suicide might undermine traditional medical ethics. So that would be the other side of it.
So kind of to dive deeper into like the requirements for Brittany Maynard and then her moving to Oregon. In the state of Oregon, to meet the requirement for physician-assisted suicide, you have to be an Oregon resident, which is why she moved there, and you have to have the prognosis of less than 6 months to live. In addition to that, patients also have to make 3 total requests for physician-assisted suicide in a span of 15 days. As Ryan said earlier, it's 2 oral and 1 written. There also needs to be a second physician who has to verify the patient's request, their condition, what they're diagnosed with, and the voluntary request of the patient. So they weren't coerced into making that type of decision. They also have to see a mental health specialist if they suffer from any type of mental illness. So like if a patient suffered from depression, they see that specialist to make sure it's not the depression that's causing them to feel this way. It's the actual condition of their livelihood and lack of life that they have left to live. The physician also has to ask the patient to disclose it to their family, but the patient doesn't have to if they don't want to. It's just required by law that the physician asks the patient to do that. And the physician must report their participation in the act of physician-assisted suicide to the state health division. That's just required by law as well.
So then, sort of finishing it off here, we have a couple of discussion questions. So the first question revolves around euthanasia. So can you come up with any specific situations or cases that you could argue for euthanasia to be considered an ethical treatment? It's come up, I think there's been something like 30 or so legal cases of trying to make euthanasia legal in states, and none of them have succeeded so far. But so maybe can you think of what arguments were people coming up with, like which specific cases? And then 2, should terminal illness with less than 6 months to live be the only prognosis where death with dignity is allowed? And then explain your reasoning on that. Do you think death with dignity should be allowed in other situations potentially? So
Thank you.
thanks for listening.
Yeah, thank you.